Representative Cragel. Here. Representative Chestick.
Here.
Representative Harrelson.
Here.
Representative Jennings. Representative Nemec.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams. And Chairman Weishut.
Here.
Thank you.
Good morning, everyone. First up on our agenda this morning is House Bill 152. I just ask everyone to make sure your phones are silenced in the room. I'll have some other instructions before we start the other bills where we're going to receive testimony. We received testimony from the public comment section on Monday for this bill. Public comment has closed. The bill will now come before the committee for amendments and discussion and then a vote. So committee, what's your pleasure on 152? Moved by Representative Jennings, second by Representative Harrelson. Discussion. Any proposed amendments? I just have a few comments and maybe we can talk a little bit about them. I would like to hear a little more discussion about the intervening component, the intervention of the legislature into the adjudication should this bill be challenged in court. I just asked Representative Rodriguez Williams to speak to that provision a little bit more.
Thank you, Mr. Chairman, members of the committee. So yes, the House Bill 152 does provide the right to intervention. I personally do not believe that it violates separation of powers principles, if that's what you're getting at. Because essentially, the legislative body can modify the Attorney General's statutory duties. The AG is a creature of the statutes, not the Constitution.
Okay. Other comments, questions on the bill? Any amendments? Oh, Representative Chestick.
I don't have an amendment. Are we going to talk about the bill in general after amendments?
Yeah, let's see if we got some amendments and we'll.
Okay.
Any amendments? Representative Cragel. Okay. Okay. Hearing no amendments. Further discussion. Representative Chestick.
Thank you, Mr. Chairman. My comment kind of gets to the point of the intervention and the separation of powers, but it goes beyond that. But let me just proceed with what I was going to say anyway. There are many reasons to oppose this bill, and I'm a no vote on it for sure. But rather than go through all the many reasons why this is a bill that is not good policy, I will focus on just a couple of them, one of which is the separation of powers question. This bill is unconstitutional. There's no doubt in my mind that this is 100% unconstitutional. It violates several sections of the Wyoming Constitution, including Article 1, Section 38 is the most obvious one. I know that in the 66 legislature, the trigger ban bill was adopted. And then when Dobbs came down, that was the trigger and the bill went into effect. And it was immediately challenged in court. And there's currently an injunction against the enforcement of the trigger ban bill. That matter is still pending in court. The Supreme Court declined to hear it early. It's still going through the trial court proceeding. And there's an injunction in place. And I believe it's a good injunction. I believe the Supreme Court ultimately, I know the good lawyer from the good country lawyer disagrees with me on this, but lawyers disagree all the time about the outcomes of things. I think the bills on the trigger ban bill was unconstitutional and will be held unconstitutional by the Wyoming Supreme Court. This bill repeals the trigger ban and replaces it with even more restrictive provisions. If the trigger ban was unconstitutional, this one is much more likely to be held unconstitutional because it goes so much farther in restricting a woman's right to choose her own health care. Therefore, even if you are in favor of what this bill is trying to accomplish, it doesn't make good sense to repeal the less restrictive matter and put in place a more restrictive matter, which is more likely to be held unconstitutional and increases the risk that at the end of the day, abortion will be legal in Wyoming. The reason I believe that this bill is unconstitutional is that the Wyoming Constitution is not something that we can overturn lightly. We have no ability to overturn it through legislative action, and this bill does that. This bill is, and the provision that the chairman just mentioned, the intervention, this bill is obviously targeted at meddling with pending litigation. There was an attempt to intervene in that litigation, which was denied. This attempts to overturn that. This also attempts to basically make that lawsuit moot. The lawsuit is about whether the trigger ban bill was unconstitutional. This repeals the subject matter of that litigation. So I thought we had a policy here in the legislature to not mess with pending litigation. And this very clearly and very directly and explicitly, I think, messes with pending litigation. So there's that problem. But that's not the biggest problem. The biggest problem is that the Constitution is not something that we can take lightly. The Constitution is not the legislature speaking. The legislature did not enact the Constitution. Therefore, we cannot change it by legislation. The Constitution is people speaking. The people voted. And we can't tell the people that you spoke wrong, that what you did was incorrect, and we're going to change what you want. So we are bound by the people. We are bound by the Wyoming Constitution, which says in Article 1, Section 38, that every person is able to make their own healthcare choices. And abortion is a healthcare choice. This bill says it isn't. This bill is attempting to overrule the words in the Constitution, which is unconstitutional. Abortion is clearly healthcare choice. Whether to take a baby to term or not is a healthcare choice. Every mother who has the ability to do so, and even those who don't, are encouraged to, as soon as you become pregnant, go to a doctor, get prenatal care, and take care of your body and take care of the baby. That's healthcare. It's a doctor telling a woman how to care for her body and care for the unborn baby. That's healthcare. Can't be anything else. So I do believe that when this bill says abortion is not healthcare, that is not a correct statement, but it's not a statement we can even make because the people say what is healthcare. And they spoke in the amendment, Article 38, Section 38. They spoke and said, we want the right to make our own healthcare choices. And the only body that has the ability to determine what healthcare means is the Wyoming Supreme Court. And here's where the separation of powers issue comes in. We are trying to tell the Supreme Court, we are going to tell you what healthcare means. We're going to overrule the people. We're going to tell you, you can't decide otherwise. That's a separation of powers issue. Supreme Court is not going to like that, and that's not going to be upheld. That makes this bill worse than the trigger ban bill and makes it more likely to be overturned as unconstitutional. We can't overrule the Supreme Court. I think the way to, if the proponents of this bill, if they wanted to succeed, would have to propose an amendment to the Constitution, the Wyoming Constitution. They haven't done so. I'm not going to speculate as to why that choice was made, but the only way to overturn Section 38 of the Wyoming Constitution is by another constitutional amendment. That is not what this bill does. It's trying to work around the requirement of the 2/3 vote of both chambers to get an amendment to the Constitution through. And therefore, I think this bill is unconstitutional. It's a bad idea. I know you don't want to take advice from the other side, but somebody on the other side is telling you this makes it more likely that abortions will become legal in Wyoming. Thank you.
Others, Representative Provenza.
Thank you, Mr. Chairman. You know, be honest, I'm conflicted here because this bill is so unconstitutional, and the points that are constitutional are the repeals. So we pass this bill. We end up in the court. Again, we reset the time. Potentially, we lose all of our abortion prohibitions, which quite frankly, I would be in support of. So part of me wants to say, vote for this so that we can ensure that women have the right to choose. So what my conflict is and why I don't say, let's just do that, let's just pass this unconstitutional law and get what we want, is because the people elected me to do good work. And that means not passing legislation that's unconstitutional, even if maybe it gets a backdoor to something that we want. You know, if the intent is to ban abortion, you got to go to the Constitution, and that means that you have to go to the people. So I can't vote for this because of the constitutionality of it. But what this bill does is repeals our abortion prohibitions.
Other comments, Representative Jennings.
Thank you, Mr. Chairman. So I view this two things. I find it interesting that we're told many, many times, or I have in my tenure been told sometimes by the other side of the aisle, that it's constitutional until the court says it's not. Except in this case, we're going to say that it's not before we ever even adjudicate or go there. But the second thing that I find interesting and that I really like about this bill is we talk about 138 healthcare and the issue of that. And the good speaker to my right here, although usually to my left, brings about a point here twice. I heard him say the baby and the unborn baby, the unborn child. What about the health care for that child? And so I see this as addressing fuller and more robust. This is one of the best written and concise bills that I've seen on this issue. And so I think this brings the definition and some light to the fact that we are talking healthcare. Who's making the decision for that unborn child? And so very much in support. Urge and I vote.
Other comment, Representative Oakley.
Thank you, Mr. Chair. On and against. So we've heard a lot about this, but I'm going to be a no vote on this bill. But it's important to understand why, right? So we listened to hours of testimony on something that's a very personal topic, a very emotional, for all sides, pro-abortion, anti-abortion. But the reality is that's not what we're discussing here. It's not. Wyoming has already passed a law that bans, is the word that's on it, prohibits abortion. So unless we were to completely change directions there, which clearly this bill does not do, that's where we're at, right? We're at, what do we want? So we passed a law, and we passed a law that passed the House, passed the Senate, got signed into law by the governor. Now it's under judicial review. That's the process, folks, right? Like that's the system. The idea that you can then take the ball and say, never mind, we're going home. We don't want the courts to do their job. And then, write into law that we, we, the legislature, may make declarations interpreting the Wyoming Constitution. Do some word mincing there. Of course, we interpret things that we're intelligent human beings, but the reality is making a declaration of law that somehow we ourselves can do our own interpretation. It's not the way it goes. So where are we? We are that we have a vehicle that has already passed both bodies, has been signed into law, and that through that process, through that discussion of being debated on the floor, some sideboards or whatever you want to put it, some caveats were put in for rape and incest, for example. So which is a relatively small compromise. If you look at this, it's very clear when you say the word ban what Wyoming law is. So, but a small amount of compromise was done in rape and incest. Now, this is trying to start over. And when I just heard it's concise, I thought, oh my gosh, that's not what I get out of this bill. So I think this bill has significant problems. We've talked about the rights of intervention. It changes it to fertilization. I think we're really going to have a problem there. We heard from the doctors that makes IVF illegal. There's issues there. So we're going to abandon this vehicle that works, that we already have, for one that I submit to you doesn't run as well. And literally that's what we're doing. Get rid of the first one. We're going to take the ball and go over here and play a different game. We're going to lose that game. So you can, people can say, you voted against a pro-life bill. Do whatever you want. This is a worse tool for where we're getting. Wyoming policymakers at this point have spoken, and for the most part, abortion is going to be relatively prohibited. That's where we're at. That's where we're discussing. How do we get there? This is a worse vehicle. I'll be a no vote.
Representative Harold.
Thank you, Mr. Chairman. So I find it interesting as I'm sitting here listening to this conversation, and it was my first year in legislation. I was asking one of our leadership at that time in legislation on my first week, and I said, is this constitutional? And he pulled out his constitution book and looked at it. And I said, well, how do we interpret that? He says, well, we are the legislative branch and we have authority to interpret the Constitution. That was what my leadership told me 2 years ago. And there's truth in that. We have some authority to interpret the Constitution. So I keep hearing Article 1, Section 38. Article 1, Section 38 is the conversation about healthcare and making the choices for healthcare. One thing we have to understand, and I think it's been stated, and I believe it needs to be restated again, is the fact that this is a life that doesn't get to make a choice. And at that point, we have to, one of our jobs as the legislature is to protect the children of this state. That's one of our jobs. We're given that charge, and this is protecting children of the state. And so I find it interesting as we keep hearing it's unconstitutional, it's unconstitutional. And I keep hearing Article 1, Section 38. And I find it interesting as I over the last couple, yesterday I had a conversation with a lawyer, and I said, hey, I need you to look at this bill and give me your honest opinion. Is this going to give us grief? And they said, it's an interesting bill. They said, it's definitely a clarifying bill. I don't believe that it's unconstitutional, maybe unconventional. That's exactly what they said. And I said, okay, thank you for your observation. The courts want clarification. The Supreme Court did not take it because they said there's not enough clarification. This would offer us the clarification. And I think that we need to be careful that we don't, we turn around and we need to be careful because we're sitting here saying, you know what? Abortion is healthcare, and we can define that, but we can't define what life is. We have to start asking some questions, I think. And at this point, as this bill, we're defining what life is. And that's something that needs to happen in this country, because there is a tearing of the fabric of this nation over this very concept. What's life? and when is life? And we heard testimony about that and all sorts of things. But Scripture says, I knit you together in your mother's womb. You're fearfully and wonderfully made. Well, that's not a blob. That's life. I knit you together. So I'm definitely on and for unconventional. Yeah, but at this point in time, we need to be unconventional in some ways, because it's time that we start defining some of these things that have never been defined.
Further comment? We see anybody else for the first time? Representative Crago.
Thank you, Mr. Chairman. So I too am going to be a no vote. And the reasoning is quite simple. I believe a yes vote on this is going to cost way more lives than a no vote. And that takes us back to the process and where we are in the legal process right now, which, by the way, I believe in. I have my bar license. I practice in those courts, and I believe in that system. And today, I think we're telling that system we don't believe in you by a yes vote on this bill. And so let's talk about that for a second. A yes vote on this, passing it through both bodies and out of this house, out of the legislature and down to the chief executive's office for a yes, for a signature. What will happen immediately is the other lawsuit will be dismissed. It's moot at that point because we have repealed the law. It's gone. Immediately, the same day, there will be a new lawsuit filed on this very law. And all we've done is push back the decision of whether or not under Article 1, Section 38, abortion can be banned. I think it can. And we already have that argument before the court. It's sitting there right now. I believe it's a good argument. I voted for that bill last year because I thought it was constitutional. I thought it was a great way to go about getting this issue before the court, because we're never going to sidestep the courts. We're not. It's not going to happen. All we're doing is pushing this down the road. There will be another injunction the second this passes, and we are pushing that argument another year, maybe 2 down the road, instead of just getting it decided. And then if we lose on that argument, to be honest with you, at that point, it's going to be based on Article 1, Section 38, and it will require a constitutional amendment. I think this bill lessens our chance of winning across the street. I truly do. I want an abortion ban to remain in place. I think this takes us further away from that. I'll give you a couple arguments on constitutionality, and these are the ones they're going to use against this bill when it comes up. At least that's what I would do if I was arguing against it. Page 3, lines 14 through 18. We reference Article 1, Section 18. That has to do with religious liberty. Religious liberty, although many of us up here are voting for this issue because of our religious beliefs, cannot be tied to a particular bill. And that's what we are doing. We are tying religious beliefs to a bill in the language of the bill explicitly. Article 21, Section 25, the same thing. It references religious practices. If you don't think that's going to get us in trouble in judicial review, I don't know how to help that, because that's what's going to happen. I brought this section up the other day. Article 1, Section 33 talks about property rights. And we're saying with this bill, we're furthering property rights. No, we're not. A living human being is not property, whether it's within your womb or out. It is a human being. That's what I'm trying to protect. This bill does not do that. We are giving the people who want pro-choice ammo. That's all we're doing, and we are going to regret it, I'm fairly certain. And so I'll quit at that, because I could go on and on with a lot of the other constitutional problems with this bill. But I'll stop there, let somebody else speak. But I am a no vote because I do believe that we are hurting our cause. Thank you, Mr. Chairman.
Anyone else for the first time? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Essentially, what this bill does is what Dobbs has called us to do, has allowed us to do. And it strengthens our abortion laws in the green books. I'll push back about waiting for judicial review. The legislature has no obligation to allow a court to decide the fate of statute it's passed. It has every right to step in and to try to remedy any deficiencies proactively. Nothing about our three-part system of government guarantees the court an opportunity to express its views on statute. I've heard the word unconstitutional thrown around so frequently this session, it baffles me. And honestly, I think it's being thrown around to fearmonger. And the people of Wyoming are tired of being fearmongered. We're tired of it. We lived through it through 2020, 2021, through COVID. And as a pro-life legislator, I'll do everything that I can to work proactively to save preborn children from being terminated within the womb. This bill, the beauty of this bill is, yes, it does state that abortion is not healthcare, because it isn't, for so many reasons. And I won't waste the body's time, but I'll highlight again that the goal of abortion is the death of a human being. And this body, the legislature, in exercise of its constitutional duties and powers, has a fundamental duty to provide equal protection for human lives, including unborn babies from conception. Furthermore, as spelled out in this bill, Wyoming's legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, which is in jeopardy when an abortion is performed, the elimination of particular gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, which we know does occur, and there's plenty of science out there to prove it, and the prevention of discrimination on the basis of race, sex, or disability. All of this is spelled out in the Supreme Court decision, Dobbs versus Jackson, Women's Health Organization. Unborn human beings should be considered persons under the 14th Amendment. And as a legislator, I believe in this bill and I will support it.
Anybody else for their first time? Representative Shestick for your second time.
Thank you, Mr. Chairman, and I will be brief. I just wanted to correct a few comments that were made regarding the separation of powers issue. And I do believe that the good pastor got some bad advice in the last cycle about whether or not the legislature can interpret its own statutes. I teach law school. I teach first-year students in the very first week of law school. I teach the students about separation of power, and I teach them about judicial review. And one of the cornerstones of our legal system is doctrine of judicial review. Somebody has to be able to, there are checks and balances. And the power of the legislature is not unchecked. If we can pass a statute and nobody else gets to say whether it's a constitutional or not, that gives the legislature way too much power. I teach students that the Supreme Court is the final arbiter of what the Constitution means. And that's a principle that has been since Marbury versus Madison in the 19th century. The judicial branch is the final arbiter of what the Constitution means, and therefore can determine whether or not any act of this legislature is consistent with the Constitution. Very basic first-year law school stuff. And therefore, I am convinced that this legislature cannot say Supreme Court can't overturn us. The people can't overturn us. We are the final power, the final authority on anything, which is essentially what this bill tries to do. That's dangerous. And I'm 100% opposed to this bill.
Representative Craig, for your second.
Thank you, Mr. Chairman. I just was going to read from a Supreme Court opinion from our good colleagues across the street. And it's actually from the case of Gordon v. State, which involved legislators making a law that was found to be unconstitutional. And what the court said was declaring the validity of statutes in relation to the Constitution is a power vested in the courts as one of the checks and balances contemplated by the division of government into 3 departments: legislative, executive, and judicial. The judiciary will not encroach into the legislative field of policymaking. However, as the final authority on constitutional questions, the judiciary has the authority on the judiciary has the constitutional duty to declare unconstitutional that which transgresses the state constitution. And so I think we just need to be clear. We as legislators should not pass laws which we believe are unconstitutional. That's where our authority comes in. We can look at a bill. We can talk about whether it's constitutional. We can even pass laws that are unconstitutional. There's no rule against that. I think it happens all the time, whether it's here or in Congress at the national level. But for us to sit here and say we get to declare what is ultimately constitutional is wrong. And that is a misstatement of our law, and that is a misstatement of our Constitution. We can make judgment calls, and I think that's what we're all called here to do, is to vote on things we believe are constitutional. I personally don't believe this bill is going to pass constitutional muster. I think it sends us in the wrong direction. It delays us getting to the answer we need to get to so that we can move forward. And so that's why I'm voting no. I believe there are a quicker way to get to the answer we need to get to, and there are unintended consequences oftentimes of voting for a bill just because it has the right word in it. We still need good legislation. The legislation we craft has important consequences, and we need to know what those are and think about them before we just vote on an issue. And with that, Mr. Chairman, I have nothing else.
Representative Harrelson for your second.
Thank you, Mr. Chairman. I find it interesting. In the last 5 minutes, we became the final voice on the Constitution. In the findings, it says the legislature, as a co-equal branch of the government, may declare interpretations of the Wyoming Constitution. The final say is the judicial branch. You go to page 12, line 8 through 18, and it says, in the intent of the legislature that each provision of this act shall operate with equal force and shall be severable, and that in the event that any provision of this act shall be held invalid or unenforceable by a court of competent jurisdiction, the invalid or unenforceable provision shall be deemed severable, and the remaining provisions of this act shall be fully enforceable. There is definite possibility that the court could sit there and say, no, that section didn't work. They could sit there in that finding and say, hey, we don't like that statement. That's encroachment upon our branch. And we don't make this law go away. That just means that they can strike that finding from this bill. And so to answer the prior speaker, was I given poor advice? Yeah, I believe I probably was. But at the same time, I also believe that there is a point where in cases where we do not have a court's ruling, as a branch of government, we have the ability to look at the Constitution and say, you know what, that's until we have a court's ruling, that's how we're going to interpret this, so we can move forward with legislation. And so I believe that we need to be very careful, because if we are not the final say on the Constitution, I don't think that's ever been said. This bill does not say that. The courts have that position. We just need to be careful that we don't put that in there as our statement, because I don't believe anyone here is making that statement. But what we are saying is, hey, you know what? When the Supreme Court did not take up the Dobbs case, I believe one of the reasons is because we have not given them those findings that they're looking for to actually be able to work upon. And this is an opportunity to do that.
Okay. Well, I'm sensing that I may be the tie-breaking vote when we call roll here in a few minutes, so I will end this discussion with just a few comments. As someone who worked diligently with the heavy lift, which was the trigger bill, I have great worries about the old adage my parents taught me about a bird in the hand. And we have a bird in the hand. We have the trigger bill signed, sealed, and delivered. At the same time, we still have a 10,000-pound gorilla sitting in the room, which is the ultimate ruling on whether Article 1, Section 38, healthcare, does in fact include a constitutional right to abortion. We don't know how the court's going to rule on that. I don't think that House Bill 152 preempts the courts. I think it just delays the ultimate court ruling on whether or not Article 1, Section 38 is broad enough to include a constitutional right to abortion. I think Gordon versus State was clear. The courts do retain the final authority. They will be the final authority. Strategically, I think I would have waited until we had a ruling from the courts on the trigger bill before I brought this bill forward. But the bill's forward. It's on our desk. It's before us today. And I will be an aye vote, given this bill lots of thoughts. I do have significant worries that at some point in the future, we may look back and say, I wish we hadn't done that. But I'll be an aye vote today. Please call the roll.
Representative Cragel,
No.
Representative Chestick,
No.
Representative Haroldson, Representative Jennings, Representative Nemec,
Aye.
Representative Oakley,
No.
Representative Provenza,
No.
Representative Rodriguez Williams,
Aye.
and Chairman Washut.
Aye.
We have a total of 5 ayes and 4 noes.
Thank you all. I know this was a difficult topic, difficult bill, and appreciate everybody's very thoughtful and heartfelt comments and effort as we dealt with this bill. Obviously, there's a whole lot more ahead for this bill on the floor, and perhaps in the other body down the hall, and ultimately to the governor's desk if all those are successful. Madam Secretary, which bill was next up on our notice? 212, House Bill 212. Sponsor come forward. I think this is your first time before House Judiciary, Representative Pendergraft. Welcome, and please walk us through the bill. Tell us what we need to know about House Bill 212.
Good morning, Mr. Chairman. Thank you for the opportunity. Good morning to the panel, the committee. Heard a lot of talk this morning about what is and what is not constitutional, and that is at the heart of what I'm bringing. I'm bringing House Bill 212, and I'll get into that in just a moment. But I want to point out a couple of things from history, if I may. James Madison was the 4th president. He was called often the father of the Constitution, and I know that you folks are all aware of this. The Congress in 1817 sent a bill to him, which would effectively have brought about what we would call today the Department of Transportation. And he looked at that and he said, I'm afraid that's not constitutional. He said an act to set apart and pledge certain funds for internal improvements, and which sets apart and pledges funds for constructing roads and canals and improving the navigation of water courses in order to facilitate, promote, and to give security and excuse me, give security to internal commerce among the several states, to render more easy and less expensive the means and provisions for the common defense, I am constrained by the insuperable difficulty I feel in reconciling the bill with the Constitution of the United States. And he was one of the writers. And he goes on, and I make this available to anybody who'd want to see it. He goes on for a couple of pages and he says, your efforts, Congress folks, are unconstitutional. The next president, James Monroe, did the same thing. They came back and they proposed similar legislation. And he said a right to legislate for one of these purposes is a right to legislate for others. He was pointing out this is a dangerous precedent to set when we just start writing law that goes beyond the enumerated powers that we're given. He goes on to say, I am of the opinion that Congress do not possess the power, that the states individually cannot grant it. For although they may assent to the appropriation of money within their limits for such purposes, they can grant no power of jurisdiction or sovereignty by special compacts with the United States. This power can be granted only by an amendment to the Constitution in the mode prescribed by it. And he goes on and he discusses enumerated powers and other such things. But essentially, it's the same answer. What you guys are proposing is not constitutional. Andrew Jackson comes along as the seventh president, the first Democrat president, and he says, guys, this is a great bill. This is fantastic. What you're proposing would be wonderful. Except for the Constitution, it's not constitutional. So we need to have an amendment to the Constitution. That amendment has never come. Brings us to today, where this is exactly as James Monroe had suggested, has gotten a little bit out of hand. I don't think there's a person in this room that would deny that the federal government has gotten out of hand, has interfered with us in ways that are not constitutional, that are beyond their purview. They legislate from the bench. We have alphabet soup agencies who are promulgating rules that have behind them the force of law that go far beyond the purview of the enumerated powers. And it's time for folks to begin to stand up, and that's what it's about. That's what I ran on. That's why I was elected. And so this bill is very important to me for that reason. I would suggest that a lot of the presidential executive orders are an example of that. One of the most recent ones was out of the BATFE. And you look at the regulations that they're coming down, where something that was perfectly legal a couple of years ago is now all of a sudden a felony. We need some checks and balances. It was stated earlier by the good representative from the county just south of mine that we can make judgment calls. And that's what this bill is about. This bill is about assigning a new standing committee. Now, I have some reservations with that because it grows government, and I don't like to grow government. But if you don't assign this task to somebody specifically, it's not going to get done, because it hasn't been done since Andrew Jackson. This bill establishes a standing committee whose task it is to look at restrictions, regulations, mandates, rules, other things that are being propagated at the federal level upon we as a state to question their constitutionality, to, as we stated earlier, to make that judgment call, and then to appeal to our Attorney General for some sort of relief. We need a place where you hear it all the time out on the street. Back on the block, we used to say when I was a soldier, we hear all the time, well, that's just not constitutional. They can't do that. And that's as far as it goes. We sit around and gripe with each other, but we don't actually make an asserted case to challenge that and find out if indeed it is. and where we are. It's my opinion.
Representative,
Yes, sir.
I'm just wondering, as I go through your bill here, if you've done the math, there's 62 representatives, 31 senators. If we create another standing committee,
Mhm.
how does the math work out in terms of the number of bodies available to staff all of these committees during the session?
Thank you, Mr. Chairman, for that question. It used to be that every representative was staffed on 2 committees. That is not true today. I myself, an example, there are several others. I have not, Mr. Chairman, gone through and done all the math and tried to do that. I do feel that this is an important enough issue that it's worth taking a serious look at spending some time. Our forefathers pledged their lives, their sacred honors, their fortunes. Surely we can pledge a few weeks of our time just to go back and check.
And just one more, do you have any idea how many items you're talking about when you speak about all new existing federal laws, resolutions, rules, regulations, decrees, orders, mandates, executive orders, and any other federal dictates? How many items do you expect this committee to review?
Mr. Chairman, that number is probably inconceivable, which is all the more reason that we need to begin doing it. How do you eat an elephant? One bite at a time. You take the thing that is on fire and you put that out, and then you go around and you look for the hot coals and you suppress those. We are on fire. Our rights as individuals, as a state, and even as state legislators, our right to and our responsibility to make good law is being usurped by a whole bunch of bureaucrats who promulgate rules with the force of law, and we stand around with our hands in our pockets and do nothing. This is a start. Will we ever finish? No. But we got to start.
Okay, questions for Representative Pendergraft? Representative Craig.
Thank you, Mr. Chairman. Representative Pendergraft, were you, I guess, hoping this would also, that this particular committee would have interim topics, interim meetings?
Representative Pendergraft.
Mr. Chairman, Representative Crago, interim topics, absolutely. I think that's where most of the work would be done. It is a heavy burden. I admit that freely, but it is a burden that I think we have to pick up. I don't think we can shirk it. We can't turn our back. We all took an oath to support and defend the Constitution, and that Constitution is completely under assault. And we have to take up our responsibility. We have to take it seriously. So absolutely.
Follow up.
Thank you, Mr. Chairman. On the fiscal note, it says it's 48,000. That seems low if we're I didn't know if that actually included the interim cost, because I would guess it should, but I'm not, it seems low if we're talking about interim travel, 14 members. But for some reason, I thought it was much more than that I thought it was about somewhere in that neighborhood per meeting we hold. It costs a lot to get us all to different places. So just wondering if you know.
Mr. Chairman, Representative Crago, that's an excellent question. It's beyond the scope of my expertise. I simply leaned on the LSO, and my understanding is that they looked at what it takes to fund any standing committee.
Representative Pendergraft, on page 4, you suggested this new committee would sponsor legislation, report to the legislature, advise the legislature consistent with any determinations and findings concerning the constitutionality of federal actions. What do you envision in terms of the legislative response other than passing a law? What would those laws accomplish?
Thank you, Mr. Chairman. I don't know that we have enough laws. I don't know that the primary responsibility of this committee would be to pass more laws. It would be to raise awareness among the legislative body that our rights to run our own state are being stomped on. And I use that word stomp deliberately.
Other questions?
I had a little bit to finish there very quickly.
Briefly.
Thank you. Well, I did have. I would point out, because somebody may be wondering where I found this. This very same bill was run during the last session, during the budget session, and a number of folks that are here in this room today did indeed vote for that. The responsibility of this committee would be, as I mentioned earlier, to appeal to the Attorney General for some relief. We have that responsibility to make a determination about what is or is not constitutional. And then the courts have the ultimate decision on that. So my vision would be, we would be sending messages up, would you please take a look at this? Maybe we bring a lawsuit against, you guys know you forgot more about the law than I'll ever know.
Representative Provenza.
Thank you, Mr. Chairman. On that same line, so say the legislation that comes out of this committee is to have the AG look at litigation. Is this committee then going to be potentially just appropriating money for the AG's office to bring lawsuits?
Representative Pendergraft.
Mr. Chairman, Representative Provenza, in my opinion, I would do whatever it takes.
Other question, Representative Craigle.
Thank you, Mr. Chairman. So on the part where you were talking about, sorry, Representative Pendergraft, where you were talking about referring stuff to the Attorney General, would that be done by resolution, or the committee would just vote on something, send it directly to the Attorney General and ask her to do something about it? Or would that actually run through the entire body of the legislature prior to that happening?
Representative Pendergraft.
Thank you, Mr. Chairman, Representative Craigo. I do believe the resolution is probably the most effective way to do it. I will admit freely that I'm very new to this process and I've never seen it done either. So I would suggest that the people that would be appointed to this committee would be people perhaps such as yourself who understand what it is we're challenged with.
Representative Harrelson.
Thank you, Mr. Chairman. So I like the idea. This is what I'm struggling with. I'm thinking logistically at this point. How do we, I heard it said once, the worst thing that ever happened to our country was air conditioning at the Capitol. And the problem is that machine, it's kind of like a chipper shredder. It just keeps throwing chips. And I don't know. So the structure of our interim committees is a 3-meeting or a 4-meeting interim. And so I'm picturing, do we take 2, 3, 4 months worth of content that came out of Washington and then review it over a 2-day committee? I mean, that could be what the case is. One of the things that I found is legislation runs a lot like news cycles in the fact that it's what's hot, what's on the conversation piece. It's what's in the forefront. And I'm not sure how, I guess I'm trying to wrap my brain around how logistically we could make that happen where we're addressing pertinent issues and not losing them. And who's the one looking at this stuff? Who's doing the research for what these things are? Is that the committee? Is that LSO? I'm just really trying to figure out, obviously, we don't have authority over the Attorney General, so it's not like we can command her to do something. We would have to work through the governor currently under this current structure. I don't know. I want to kind of, I love the idea. I just don't know how that works. And if this is more of a task force issue or if this is a committee issue, and I see a representative teeing up to the mic. So I'm going to be quiet.
Let's let Representative Pendergraft respond to the question.
Thank you, Mr. Chairman. Representative Harrelson, I too have spent a lot of sleepless nights thinking about that. I mentioned earlier the fires. And I do think that there is probably the way that I would vision is you'd have a group of citizens who would get together who are steamed up about something regardless of the reason. And that they would petition their government, which would be us, for a redress of their grievances. And because we only have a limited amount of time, because we are a citizen legislature, and I don't want to change that, we would take the most pressing of those issues and address them. I think the result of that would be encouragement from the people of the state of Wyoming. They would say, look, this is something I've been upset about. I brought it up to this committee. Here's a response. At least it's a start. Will it ever be enough? I don't know.
Representative Jennings.
Yeah, Mr. Chairman. So in response to that, we'd be creating a standing committee. So it would work the same way it does now for any standing committee. Public would come, bring issues. In the end, the committee itself would put issues before management council, and then they would, unless we change that rule, then they would give the top topics to be looked at. So I don't see that it would be any different than any other standing committee.
Representative Provenza.
Thank you, Mr. Chairman. And because it won't be any different than any other standing committee, so we're talking about meetings, and I imagine a lot of research. We're going to need research for this, right? And so was there conversation about, so with this fiscal note, I assume this 48,000 is just to help pay for the costs of the meetings themselves, but I'm thinking, do we need another additional LSO position to be able to provide that information to the committee? Is that something that, would management council add that, or would we need to appropriate that with this bill?
Representative Pendergrass.
Thank you, Mr. Chairman, Representative. I really don't know the answer to that. I would remind you of the pledge of our forefathers that pledged their lives, their fortunes, their sacred honors. I think it's worth doing. And I think if we fail to act, we will just be completely overrun.
Thank you. Anybody else in the room wishing to testify on House Bill
Mr. Chairman.
212? Representative Jennings.
Mr. Chairman, in response to that, I mean, we could look at maybe disbanding blockchain or something like that, moving that staff over to take care of this.
Anybody else in the room wishing to testify on House Bill 212? Go forward. Representative Block. Representative Slagle. Good morning. It's First Timers Day at House Judiciary. Welcome to the committee. All right. Representative Block.
Thank you, Mr. Chairman and committee. I'll be fairly quick. I just wanted to, I'm really speaking on the behalf of my constituents here. I knocked on a lot of doors. One of the major topics at the door is federal government overreach and, quite frankly, loss of sovereignty of our state. And that's the biggest concern. And I think COVID has proven to us that the federal government is very happy to force compliance of, through the state, all the way down to the state, through unelected officials and unelected organizations. That's been proven. Okay. They also are very clear. They're happy to do that with money. Okay. They love to give us money with strings attached. It's all been proven. People at the door, these were the things they hammered me on as I walked out and talked to my constituents. We, the people, have proven that compliance simply emboldens them, right? We always think, it's easier to comply, but we know that that's not true because we know what the result of that is. That's the next overreach, and it's coming quickly. In going out there and walking the doors, the people made it very clear. There's a growing, there's a groundswell that people are starting to realize this federal government overreach is affecting us and it's crushing us. So I realize there's lots of complexities in this. I understand it completely, but I can tell you that the people are saying we need to take this serious as a body. We absolutely must. The folks are understanding it and they're expecting us to do something. Now, I understand there's lots of logistics, there's lots of complexities. I do understand that. But we absolutely, in my opinion, I'm strongly for this bill because we need to take action here. There's almost no question. At least my constituents are saying that, and I'm guessing many others are saying that as well. The last thing I wanted to say, I know that there's a lot to do here, and I know this has already been said, but I'll say it quickly. It's a huge issue, right? It's Mount Everest, okay? We're not going to climb it. We're going to jump to the top, one step at a time. I won't use the elephant analogy. Some people don't like it, but that being said, we know it's one step at a time. But I think we start taking those steps and commenting about the money. I understand this is not practical, but many of us, we would gladly support that committee for free. Thank you. I'm in favor, and I welcome questions.
Thank you, Representative Slagle.
Thank you, Chairman Washington Committee. I am Alan Slagle, representative from House District 2. I have actually been working in the background on this bill for probably the past 3 years, trying to get it brought to the legislature. And I watched it fail in committee several times. And I just echo the comments of the previous representative. I think this is something we need to look at. And I heard from many of the people that I talked to campaigning this year that they're concerned about the federal reach in our state. And I think it's something we definitely needs to be addressed. Thank you for your time. I'll stand for any questions.
Thank you. Any questions? Seeing none. Anyone else in the room wishing to testify on 212? Seeing none, close public comment. Committee, your pleasure. Moved by Jennings. Oh, we have one on. We have some Zoom testimony. Okay. Okay. So obviously some of our other legislation is not going to make it. So us for House Bill 212, we have Marty Halverson waiting online. To bring her in. Ms. Halverson, are you there, please?
Yes, I am. Good
Welcome.
morning.
Welcome to House Judiciary. Tell us, we do have two other bills we're going to try and work this morning.
Yep.
I'm not very optimistic at this point, but tell us what you want us to know about House Bill 212.
I will be quick. I appreciate your time. My name is Marty Halverson, and I live way over here in Star Valley. House Judiciary was my committee for 4 years, the hardest working committee and the hardest working legislature in the country, right? I urge your support of House Bill 212. I've been a member of the Republic Review Committee since its beginning several years ago, along with Representative Slagle. And we just got together. We all met at a meeting and organized ourselves very loosely, but with the same goal: to review Wyoming's relationship with the national government. We see House Bill 212 as an ideal mechanism for accomplishing that. The meat of this bill is on page 4. We envision a standing committee that will review federal actions, past and present, and report findings to the legislature. We expect this federal review committee will review bills with an eye to assessing where they fall on the spectrum of blatant, untenable, unconstitutional federal overreach to constitutionality and Wyoming state sovereignty. Thank you, Chairman Washington Committee, and I'm available for any questions.
Questions from Ms. Halverson, Representative Provenza.
Thank you, Mr. Chairman. Ms. Halverson, would you support a standing committee that would investigate your actions into spying on the governor, Senator Barlow, and myself?
I'm afraid I don't have a clue as to what you're talking about.
All right. Any other questions? Hearing none, thank you. And do we have Scott Brown queued up? Mr. Brown. Thank you, Ms. Halverson.
Can you hear me?
Scott Brown.
Yes.
Yes, please state your name for the record and tell us briefly what you want us to hear. We have two other bills that we're going to try and get to this morning, so we're trying to be brief.
Okay. Well, Scott Brown from Bighorn County. I am also the chairman of the Republic Review Committee that Marty mentioned. I'm just going to go straight to respond to a couple of the questions. One of our intentions in drafting this bill was to keep these issues out of litigation. Our vehicle to accomplish what we want to accomplish is to identify in Wyoming some of the issues that are worth fighting for, some of the government overreach, and then elicit the support of other states. Some of our thinking is borderline nullification. What the federal government is doing in its overreach is something that they do not have the authority to do. And so Justice Scalia at one point said that he made a statement that the states are sovereign, they just have to start acting like it. And this is our first step as a state to start acting like it. And then, of course, we would enlist the help of other states. There are other states who already have federal review committees. There are a number of states that are also looking at similar legislation to what this bill does. In fact, we have one state that kind of copied this bill. And my understanding is it's being looked at currently. I'll stand for questions if there are any.
Thank you, Mr. Brown. Any questions for Mr. Brown? Representative Shestak.
Yes, Mr. Brown, thank you for your commentary. You said that at the beginning that one of the objectives is to reduce litigation, and then you invoked the possibility of nullification. It seems like this committee has nothing other than litigation as a possible remedy. So this seems to me like it really is going to greatly increase the risk of litigation. Every time we try and nullify a federal rule or statute, there's going to be a lawsuit. I'm not sure how this bill reduces litigation.
Mr. Brown.
Well, again, I'm not an attorney. Our objective in our deliberations were to try to craft this such that it would not that we could avoid litigation, because we do not feel that the courts are the final arbiters of these state issues. The arbiters are the states themselves. And so as a state, we need to stand up, we need to establish a coalition of states, and we need to stand up and say, federal government, we never gave you the right to have a Department of Education. So the Department of Education is not something that you can force down our throats.
All right, Mr. Brown, we don't want to get off in the weeds on any particular federal department. We understand the whole issue of overreach and state sovereignty. So we do have Mr. Mobley waiting in the Zoom world. Thank you, Mr. Brown.
Thank you.
Yes, my name is G.R. Mobley, and this bill is actually the reducer of litigation and the reducer of future bills. And as a matter of fact, current bills, by clearly utilizing the fundamentals of compact law or the fundamentals of the law and the nature of constitutions, because the parties are the final arbiters. The Constitution was very limited and defined, and the jurisdiction of litigation for the federal courts is limited to those things arising under the Constitution, as Article 3 states. Therefore, issues and matters that come forward, I know Marbury v. Madison was already referenced in previous testimony. Marbury v. Madison, the first thing that Marshall claimed was they didn't have jurisdiction over this matter, and then he made a ruling. The fact is that the states are the parties to the compact. They're the ones that delineated the enumerated roles, responsibilities, powers, and property that was defined to the federal government for them to possess and exercise. Anything as it was ratified throughout the different states, they clearly stated that if it was not enumerated, the federal government could not meddle with it. And therefore, anything that is not enumerated actually doesn't fall underneath the jurisdiction of the federal courts. And this is, like, again, the fundamentals and the tenets and nature of the constitutions. In the documents I provided.
Mr. Mobley,
Yes, sir.
I don't think the committee disagrees with the whole overreach question. What I think the more pertinent question for us this morning is this creation of a standing committee the appropriate response for the legislature? So if you could
Yes,
focus
absolutely.
briefly, we have two other bills to get to on that question.
Sure, absolutely. If everybody is willing to do some homework, I provided you 5 documents. James Madison clearly delineated exactly what needed to be done when the federal government overreached. And the first document was written by Thomas Jefferson. It was the Kentucky Resolutions of 1798, where he audited the Constitution against the Alien and Sedition Acts and actually defined how they were violating this and called for the other states to join in interposition. Madison and the Virginia Resolutions of 1798 responded in kind, and Madison called upon the other states to take the necessary measures and, interpose on the federal government. In 1799, Jefferson basically made a final resolution that dictated that because the other states weren't willing to join, that they needed to take other measures. And in Madison's response in 1800, so this is the 4th document that you have, he clearly delineates why the states must act. In the essence of our nation, every U.S. citizen has the obligation to support and defend the Constitution against enemies, foreign and domestic. And every state in this union can actually require and compel every person to defend that Constitution based on the fundamental oath of a citizen. And that same oath is even borne legally by our representatives in our government. And so
right. Thank you, Mr. Mobley. We're really pressed for time this morning.
Okay.
I think we've heard the points and we'll look at those documents. Any questions from the committee for Mr. Mobley? Hearing none. Thank you again, Mr. Mobley. Sorry to kind of cut you off. I know you had more to say, but time is of the essence in the legislature. Any bills that don't get out of committee by Friday morning are done for the session. So we are really up against the clock, but I appreciate your participation this morning. Anybody else wishing to testify on 212? Okay, I'll close public comment committee. Moved by Representative Jennings. Second by Representative Nemec. Any amendments?
Yeah,
Representative Jennings.
Mr. Chairman, I have 3 amendments, all on page 4. The first on line 6, where I'd strike the word all and review federal actions. I'd put an S on the action. All is a large bite. And this elk might be bigger than we can do in one time. So that would be the first one. Do you want to do all 3?
Let's get one at a time. Debbie, do you have that one on line 6, page 4? Strike the word all and add an S to actions. We have that? Okay, is there a second to the motion? Second by Representative Rodriguez Williams. Discussion on the motion? Question being called. All those in favor say aye. Aye. Those opposed, no. That amendment has carried. Do you have a second amendment?
Yes, Mr. Chairman, on line 16, starting with this duty, I would strike the remainder of 16, 17, and 18.
So just the words "this duty" on page 6 on line 16 and then nothing else?
No, sir. Starting with this, that entire sentence.
Okay, so we take
16,
16 would end after Constitution.
Yes,
and
sir.
the remainder of that paragraph be deleted. The second by Representative Provenza. Debbie, do you have that? Go on line 16, we'll end that paragraph after the word Constitution. Committee,
I think the semicolon would need to be moved.
a semicolon instead of a period.
It would need to be moved.
So we're going to replace the period after constitution with the semicolon.
Yeah.
Everybody clear? All in favor, say aye. Those opposed, no. That amendment has carried. Another one, Representative Jennings?
I do, Mr. Chairman. Going to line 21. Because we do these things already, I would, after legislature, I would put a period. Because that is the purpose of the committee.
Report to the legislature, period. Striking the remainder of the paragraph?
No.
Okay. go
Report to
ahead.
the legislature and advise the legislature. So there might be findings or things of that.
Report to the
nature that they
legislature
might-
and advise the legislature, period.
Yes. And then a
Striking the
period.
remainder.
Striking the remainder because that's what a committee does anyway.
Is there a second? Second by Rodriguez Williams. Debbie, do you have that? So we're at line 21 on page 4. We're going to put a period after the second legislature and then strike the remainder of the paragraph. It's already been seconded. Committee, all in favor, say aye. Those opposed, nay. That amendment has carried. Any further amendments? Question on the bill, comments on the bill, Representative Folker.
Thank you, Mr. Chair. I just wanted to say, I really appreciate this effort by Representative Pendergraph and some of the others. And I know I heard it. Sometimes we do get very frustrated, clearly. At one point it was said, we're on fire. And I think we all, agree. I think we all share a frustration. But I think it's also important then that we find the most productive ways and solutions for that. We just improved it, Representative Jennings improved it some, but I just don't think I can support the expense of creating this whole committee, reviewing, again, he made it better because I had all federal action, but reviewing federal action needs to be more targeted than that. And I was going to say, like, it's an academic pursuit. Like I would be on this, committee and I support it. But if people want to get together 2 or 3 times a year, then they can do it on their own. And to Representative Locke said that we do it for free. Well, I think that's the answer, not creating another governmental committee and agency for it. I think a lot of us support this, but support the concept, but then we can get together and use our brains without creating another governmental committee. So I'll be a no vote.
Further comment?
So, Mr. Chairman,
Representative Jennings.
Mr. Chairman, I just was thinking maybe that we would see the good counselor bring an amendment to switch out blockchain for this committee.
Representative Craigle.
Thank you, Mr. Chairman. I too appreciate the effort. I'm probably going to vote on it, yes, in committee, just because I'd like to hear the debate on the floor. This will be a fun one. I probably won't vote for it on the floor because I think if we're doing our job properly, these issues are going to get handled in the other 10 committees. And if they're not, then we're not probably doing our job, and we need to look at that more closely. And those are, I think like like Representative Oakley just mentioned, we as a group can get together. If there are people who believe there's issues, we can get those issues before management council. We can get those issues before the other committees without growing government, because that's what it does. I'm not always necessarily opposed to that. And so that's why I said I'm actually interested in the debate. I'd like to hear some more pros and cons of this idea. So I'm gonna vote for it here, but knowing that I probably, when we get to the floor, probably won't, but I might change my mind. And so just wanted to say that. Thank you, Mr. Chairman.
Thank you for the comment. I'll add my last comments or recall the question. And I just, absolutely agree that there's federal overreach. The question is, what's the best mechanism with which the state can push back against that? And, recommending litigation after litigation after litigation by the Attorney General on a target-rich environment of federal overreach, I'm not sure that that's going to serve the purpose. And even some of the witnesses had conflicting ideas about whether we were going to pursue litigation or whether nullification of some sort was an appropriate response. And lastly, the scope, the magnitude of, we define federal action on page 5 as all new and existing federal laws, resolutions, regulations, decrees, orders, mandates, executive order. It's a massive undertaking, and I think it's beyond any one committee to try and attend to that. So I'll be an aye vote today, get it on the floor. We have ample time on the floor to debate these types of topics, so I'll be an aye vote. Representative Provenza.
Thank you, Mr. Chairman. I wasn't sure if I was going to say anything or not. I can appreciate what we're trying to do. And I like the idea of a fact-finding body, right? Like, let's get to the bottom of something, because I think that there are certainly things that are misconstrued and then ultimately end up on the steps of the United States Capitol in an effort to insurrect. And while all I keep hearing is the federal government's overreach, doing this, doing that. And I think it's just emboldening people, and it's angering people. It's inciting rage. And sure, are there things that the United States government are doing that I don't necessarily agree with? Yeah. But we don't talk about it in a way that is honestly fair. I think that there's plenty of great things that the United States of America does. That is what this state is part of. We are a part of the United States. And when we talk about federal overreach, we remove ourselves from that. We remove the patriotic duty that we have to this country. And so, again, I respect and want to support a fact-finding mission. What this bill comes on and basis, it bothers me. So I am a no vote.
Representative Chestic.
Thank you, Mr. Chairman. I will be brief. I am wearing a lapel pin today that has a American flag and a Wyoming flag intertwined, because I did take an oath to serve both constitutions. And I intend to do so. And I think this, I agree with my colleague on the other side of the dais here, that this kind of committee only serves to stoke fears. I think there's lots of ways in which every committee should look at these things. As what other commenters have said, this is the job of every committee. And having a separate committee that looks like we're trying to take Wyoming out of the union, it almost looks like a bill to secede from the union almost at times. That's what it kind of has a flavor of, to me anyway. I just think it sets a bad tone, and I really would prefer to have these kinds of issues dealt with in the other committees.
Question being called. Roll call on House Bill 212.
Representative Cragel.
Aye.
Representative Chestic.
No.
Representative Harrelson. Representative Jennings. Representative Nemec.
No.
Representative Oakley.
No.
Representative Provenza.
No.
Representative Rodriguez Williams.
Aye.
And Chairman Washut.
I love being the tiebreaker. Aye. Next bill for consideration is House Bill 231. Representative Cragel. Walk us through the bill. Congratulations, Representative Pendergraft.
Thank you, Mr. Chairman. Committee members, Barry Crago, House District 40. I bring to you House Bill 231, Public Defender Funding Amendments, and ask for your favorable consideration today. It's a pretty simple bill. It takes out the words "and federal" from the statute setting forth how the public defender budget is set. A little bit of background, the state public defender at this point does not have any federal funds within their budget. And it's only state and county funds. And so the state pays 85% of the public defender's budget, the counties pay 15%. There's an opportunity to get some, and it might be one-time funding for some mental health. I think one of the things, there is some funding available for mental health. I think that the state is reluctant to take that because as the statute's written, if we take federal funds, the counties then have to match 15% of that. Whereas if there's the opportunity to get some of these grants, the counties would not have to match it with this bill. We could use the money. And the nice thing about it, it never rolls into the state budget for that purpose. If the funding doesn't become available, if the funding dries up, we don't need it, whatever, we're going to keep operating the way we always have, which is the 85-15 split. And I think it's ironic that somebody who works in the county attorney's office is bringing a public defender bill to help them get money. So just wanted to add that for a bit of comic relief. But anyways, it's really that simple. It's just going to allow us to maybe go after some federal grant funds that are available without actually taxing the counties and making them come up with a higher amount to make the 15% match.
Representative Cradle, on page 2, line 5, the word calculation. Can you elaborate a little bit on what you're getting at with calculation of the budget?
Thank you, Mr. Chairman. That was just the drafting word used by our good lawyers within the legislature. That's determining the 85-15 split. That's what the word calculation is referring to, which is in a different, it's in a different part of this statute. It's in the subsection between A and E, and I can't, without having my book in front of me, I can't tell you which one that is, but that's essentially what that's talking about, is the 85-15 split.
Other questions, Representative Jennings?
Thank you, Mr. Chairman. Representative Crago, I understand why you're doing this, but have you given thought to, it seems like that this federal money might be one-time money. And so if we strike this out, it seems like that might be, should we be monkeying with this legislation for one-time money? What's the long-term effect? What if there's something on the federal side that comes down differently? It looks to me like that if we strike this and then say there's federal money available on a regular basis that would alleviate some of the 85% for the state, that we would be on the hook for the 85% period, that we would not be able to calculate federal money into that. So there might be some unintended long-term consequences.
Thank you, Mr. Chairman, Representative Jennings. So the state public defender still has to go through the annual appropriation process. And so if for some reason, let's say the federal government decides to begin funding the entire process or the entire, department for the public defender, I think we can still use that money. The budget just may become zero. The state part of the budget may become zero.
Further questions, Representative Crago?
Yeah, follow up.
Representative.
On line 2, Mr. Chairman, thank you. On line 2, this would read, the state funding of the public defender shall be 85%. So under your analogy, say the feds decided they were magnanimous and wanted to fund the entire program, we'd still be on the hook for 85%, is what it's saying.
Representative Crago.
Thank you, Mr. Chairman, Representative Jennings. That's why the disclaimer in Part E is there, is to protect against that. That's what that language is meant to do, is that would not become part of the budget. And if anybody has any suggestions on how to draft it better, I'm always up for that. I never take pride in authorship ever. If we can make it better, let's do it. But that is the intent. We're trying to protect against the counties having to come up with 15% of a grant, because most of these grants don't require a match that we're looking at or that we're talking about. And if we don't need to, let's not spend state money.
Okay. Ms. Lozano? State your name and agency for the record and tell us what we need to know.
Thank you, Mr. Chairman. Diane Lozano, State Public Defender. Sorry you've had to see me twice in the last 4 or 5 days. So I guess I don't know exactly where to start. The way that I read this section that we're proposing have portions repealed is that if I were to seek federal grants to help us, and I'll give you examples of what I think that looks like, it would reduce our budget overall. And it would come out of our general fund funding. And I would tell you that we're not seeking to have the federal government fund the public defender's office. I don't want to be tied to the federal government and all the rules and regulations that come with grants unless it would help us. We're not seeking to grow our budget. I can tell you that I think the state of Wyoming does a good job funding the public defender's office. So it isn't an effort to increase budget or increase government. So if we were able to seek grants, I can tell you we would be very discerning. But in my mind, our goal would be to always seek grants that would be one-time funding, but to have that option over time to answer Representative Jennings' concern. So one idea I have is that the Bureau of Justice Administration provides technical assistance through grants. I think my office needs a better case management system. I think the data I report to you is accurate, but I think we could dig deeper, and I can't do that with my current funding. So maybe a grant I would seek is for the federal government to pay for that case management system based on best practices that they've helped other public defenders' offices do. We would do that over one biennium, and then we would be done. In terms of helping the justice system, I can tell you that a lot of defendants languish in jail because they can't afford to get a substance abuse evaluation, mostly in misdemeanors, felonies. They get a substance abuse evaluation once they get sentenced anyway. But if defendants could get substance abuse evaluations, they could get sentenced on their DUIs. They could have a plan for rehabilitation for courts, and it would move those cases along quicker. So maybe there's a grant out there that helps me help people get substance abuse evaluations, or helps me find resources that my clients can access for substance abuse evaluations. And I know, I think you've heard about sort of the crisis we're in right now with the mental health system in terms of defendants sitting in jail who aren't mentally well enough to assist in their cases or have been found not guilty by reason of mental illness, but they have to go to the state hospital, and the state hospital's understaffed and it's taking 5 or 8 months. You know, we have handfuls of cases that are languishing in the system for a year, and courts can't work on them. Prosecutors can't get justice for their victims. Defendants can't move on with their cases. And so maybe there's a grant out there that helps me better assess my clients who need to go to the state hospital or not, or get them the treatment they need in jail, so we don't need to go to the state hospital in all of our cases. And so those are just ideas that I have. I doubt that we would ask for it every budget year. Those are just some ideas I have, and I don't even know what's out there. What we'd like is the option without burdening the general fund or the counties any more than they already are. But I will tell you that our budget's good. I don't know what the next budget request looks like or what I'll be asking of the legislature as a whole.
Right.
But the public defender's office is okay. We would just like to have an option that doesn't reduce our ability to do the job that we're already doing, if
Ms.
that makes sense.
Lozano, if you know, do other state agencies have these type of 85-15 calculation splits in statute for their funding?
Mr. Chairman, I am not sure. That's just always the way we've done it. We bill the counties once a year for their 15%. It's based on a formula that I couldn't remember off the top of my head. My fiscal office and the budget office does that, but I'm not aware.
Okay, committee, any questions for Ms. Lozano? Representative Jennings?
Thank you, Mr. Chairman. So do you have a copy of the bill, Ms. Lozano?
I do
does
now.
So my concern there is that we open this up and be a problem with something that we might not see coming from the feds. And so if we were to go say on line 6, and we said shall not include one-time federal grant funds on line 7 expended by the state public, would that get us to the same place? And then we wouldn't need to strike out and federal on line 1, so that if you got opportunity for grants, it would not include one-time grant funds coming in. It seems like that might leave it the protection that's there now and still give you the opportunity for grants.
Ms. Lozano?
Mr. Chairman, Representative Jennings, I think that makes sense. I think it probably accomplishes both what's already in lines 5 through 8 in that. And I understand the representative, your concern that, we don't want to make it seem like the federal government end up funding all of this, because I don't think that's a good idea for a number of reasons. The way I read it is sort of the protection, the way it reads right now, that our budget would not change in terms of what this body decides we need for a biennium. And that the grants are just something that doesn't reduce to 85% or doesn't increase to 15%. So, as a lawyer, I think that the way it reads accomplishes those concerns, but I also think that the representative's suggestion probably does the same. As I ramble
Further questions?
about that.
Representative Craig, bring us home.
Thank you, Mr. Chairman. I appreciate the good representatives. And we can talk about it when we get to the amendment portion. I'm probably not going to be in favor of that, and I'll explain why when we get to talking about amendments. I think we may be able to get to the same spot. I'm just not sure sitting here today we can do it on the fly if we're trying to get to another bill. But anyways, I think this is good. It's a good way for us to go after some funds without taxing the state and our counties more than they already are.
Okay, any further comment on this bill? Mr. Odekoven?
Mr. Chairman, Byron Odekoven, the Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. Initially, I was not going to comment on the bill, wanting to listen to it a little bit to ascertain whether it was appropriate. And I just want to share with the committee that part of what comes across my desk are the federal notices on grants and opportunities from the Bureau of Justice Assistance. And as stated, and as the examples used, some of them do involve mental health, access to courts, which for our membership on the detention side would make a significant difference in reducing some of our state and county expenditures when we are in fact housing people in jail pending the assessments that were described. So I would be in favor of the idea that if we can utilize some of those grants in this manner, which are not available to law enforcement, based on what I saw in the grant offering, if you will, it would have to be a state agency, may very well be applicable to the public defender's office, would help alleviate some of our detention woes in this regard. Thus, we would be in favor, Mr. Chairman.
Thank you, Mr. Odekoven. Any questions? Seeing none, thank you. Anyone else in the room wishing to testify on House Bill 231? Seeing none, I'll close public comment. Committee, what's your pleasure? Moved by Oakley, second by Representative Nemec. Any amendments?
Yeah, Mr. Chairman,
Representative Jennings?
I would move an amendment that would unstrike on line 1, page 2, and federal funding. And I would move that on line 6 that we would put in, we would strike any authorized federal funds to be and put in one-time federal grant funds. I'm all in favor of these entities being able to get the federal grant funds and perhaps not harming, I don't want to harm their budgets, and they might have a windfall that would help there. I don't like making that completely open so that it becomes a funding source that we become tethered to federal strings that might come with that. And I just think we need some sideboard there. And I completely support the idea, but without the sideboard, I don't think I can support it. So
there's a second. Second by Haraldson. So let's clarify the amendment. The proposed amendment is to unstrike the stricken language on line 1, page 2. And then on line 6, it would read, want to tell us, just read it as you see it reading on line 6 and 7. Representative Jennings.
Yeah, Mr. Chairman, it would, but the defender budget shall not include one-time federal grant funds expended by the state public defender. So they could get the grant, but it would not count against their.
Debbie, do you have that? Want to read it back for me?
Shall not include one-time grant funds for the state public. Federal grant funds. One-time federal grant funds.
Mr. Chairman, I don't think we want to harm state. There might be grant funds or something.
Everybody clear on the amendment? All in favor of the amendment, say aye. Oh. Representative Craig.
May have a little bit of discussion, Mr. Chairman.
All right.
Thank you. Sorry, I'll make it quick. I recognize what Representative Jennings is trying to do, but two things. One, this makes these two provisions now contradict each other, which I don't think's a great idea. Two, I mean, I'm not sure we want to limit it to, one-time funds. I mean, I understand what the public defender was saying was, what if those funds extend over 5 years, for example? Is that a one-time fund? Probably not. And so I feel like the whole point of this is so we can actually save money at the state and county level. I mean, that's what I'm trying to do is say, okay, we have this opportunity to probably save some money. I mean, I think the public defender, Ms. Lozano, testified that she may actually be able to lower her budget, possibly if we're able to do something somewhere else, maybe not, but it also would, I'm just not sure we want to limit it to, a one-time annual expenditure. I'm willing to work on language to cover that fear or try to, if I don't know if we can get to the exact same place, but I understand what you're trying to get at, that we don't want to become attached to that federal grant money. And I get that. I'm appreciative of that. I don't either. And so I just don't know if this amendment gets us exactly where we need to go. So I'm a no on the amendment, but I'm a yes on trying to figure out something that works for everybody.
Mr.
Discussion on the amendment.
Yeah, Mr. Chairman,
Representative
I think
Jennings.
one-time funds would cover. I mean, it might last 10 years, but it was a one-time grant and it might be stretched out. One time just means that you did the application and you got the money. If we feel that we maybe could even strike one time.
Further discussion on the amendment? Seeing none, all in favor of Representative Jennings' amendment to unstrike the stricken language on line 1 and reference one-time funding on line 6 and 7, say aye.
Aye.
No, say no. No. I think the amendment has failed. Back on the bill, further amendments? Sensing a question. Roll call on House Bill 231.
Representative Prego,
Aye.
Representative Chestick. Representative Harrelson. Representative Jennings. Representative Nemeth,
Aye.
Representative Oakley. Representative Provenza,
Aye.
Representative Rodriguez Williams.
Aye.
And Chairman Washut.
Aye.
We have 7 ayes and 2 noes, sorry.
And with that, House Bill 231 has passed House Judiciary Committee, which takes us to House Bill 241. Representative Provenza. You have to go to the next door.
All right, committee. Representative Provenza, go ahead and introduce us to your bill.
Thank you, Madam Vice Chair. This was sprung on me last minute to deliver, so I'll do my best to answer all of your questions. This bill comes before you today, House Bill 241, prohibiting sexual relations with persons in police custody. I know the good bringer of the bill has had some issues in his specific area, I believe, and has had conversations with constituents. In my conversations with the Peace Officer Standards and Training Office, there have been, I believe since 2019, June 2019, there have been 10 cases that have been investigated and decertified related to sexual contact with persons in custody. And 4 of those have resulted in some charges. I don't know the nature of those, but it is my understanding that there isn't necessarily a specific statute that points to that it's prohibited behavior. The problem being with sexual relations with folks in custody is that they often could be viewed as coercive due to the nature of the power between the 2 entities. So ideally, what we would like to see is that these relationships don't happen in custody at all. Certainly would be, you know, if folks want to pursue those after custody is no longer an issue, that would be fine. But having instances in which folks have struggled with this idea of consent in these settings, and this would include, because it's including peace officers, this would be correctional facilities, this would be on patrol. Anybody that falls under that definition, that would be Wyoming Statute 6-1-104, or that 72-101. So this would also apply only to folks who are responsible for effecting the arrest of the victim, detaining the victim, or maintaining the victim in actual custody. And then in addition, this also includes knows or reasonably should know that the victim is under arrest, being detained, or is in actual custody. So that is the extent of the bill. Pretty simple and straightforward, Madam Vice Chair. So I will stand for any questions that you have.
Thank you, Representative Provenza. Do you have a key witness or anybody you'd like to bring forward to testify?
Madam Vice Chair, I have people I would bring. I don't have them today, Madam Vice Chair, so I apologize, or that I know of, unless the Peace Officer Standards and Training Office is online, or anybody who may have been here via Zoom.
Thank you. We'll go ahead and open it up for public testimony. Is there anybody that would like to come forward to testify on? Oh, Representative Haroldson.
Thank you, Madam Vice Chair. So on page 3, line 8 through 13, where it says evidence of marriage as defense. So if, and maybe I'm completely off here, and just give me a clarification. So if it would be a situation where someone who is in a marriage relationship and one person was in law enforcement, the other person made some mistakes, and they got put into this situation, would that automatically put them into this and basically out of line with the law? Or is this a situation where they turn around and get married and saying, oh, now that we're married, you can't prosecute because we're now married? So just, can you give me clarification on that?
Representative Provenza.
Thank you, Madam Vice Chair. That's a good question. I think it's when we're talking about any of these instances, I think it would be at the time at which the act occurred. Certainly, I think even if something weren't, I think part of what this was supposed to do was to provide some defense for folks who might have a marriage, they're married, and are not necessarily trying to issue consent issues. I guess I'm sorry if I didn't answer that question very well, but I think it's a good question that I don't have the answer to.
Any further questions?
Yeah.
Representative Jennings.
Thank you, Madam Chairman, lady. So Representative Provenza, we use in the title, it's with persons in police custody, and yet all the way through this bill, we use the word victim. Are they not just an alleged victim until that's adjudicated? It seems like we might run into a problem. We've used the word here at least 10 times.
Representative Provenza.
Thank you, Madam Vice Chair. We had this discussion on a bill recently, which I think is why you're bringing the question. I think it would be, certainly, it's up to the committee. We could insert, probably in many of these cases, person, because that is what the statutory language typically, I think, would be. Correct me if I am wrong in any of our other statutes, but yeah, any actor who inflicts sexual intrusion on a person commits sexual assault in the second degree if under circumstances not constituting sexual assault in the first degree. So if you wanted to, Representative Jennings, you could amend the language.
Any additional questions? Okay, with no additional questions, we will open it up for public comments. Is there anybody in the room? Mr. Odekoven, come forward. Please state your name and who you represent.
Very good, Madam Chair. Byron Odekoven, the Executive Director for the Wyoming Association of Sheriffs and Chiefs of Police. Let me start by saying I appreciate the sentiment of the bill. And in fact, we wrestled with this very issue several years ago. And in fact, I would say that the actual bill is not necessary because it is well covered and addresses some of the points that were raised as well under 62303, section I, VII, which is 7. So part of it is who all does it encompass? And the bill before you today specifies peace officers only, if you will. Although the existing statute under 62303 talks about an actor is an employee, independent contractor, or volunteer of a state, county, city, or town privately operating adult or juvenile correctional system, but not limited to just jails, penal institutions, detention center, juvenile residential rehabilitation center, adult community corrections facilities, or secure treatment facilities, and the victim is known or should be known to be an actor, to be a resident of that facility, or under the supervision of a correctional system. The idea that was promulgated when we discussed this and passed this bill with our support several years ago had to do with the idea that someone in a position of authority could exercise undue influence and end up in a sexual situation, and that would clearly be wrong as defined under the statute that was passed several years ago. So I would say the statute before you today, I think, would somewhat muddy the water, somewhat call into question back and forth, were they or weren't they? How might this flow when it's already clearly and well-defined under 62303, Madam Chair?
Thank you, Mr. Odekoven. Any questions of Mr. Odekoven? Representative Oakley.
Thank you, Madam Chair. So I should have had this all worked out, but I believe, so this could be for either one of you. Because that's what I thought at first. I mean, this is already, this is already in statute. I think the original bringer of the bill's idea was that what wasn't included in that statute was if somebody, let's say, like out in the field was under arrest versus the correctional facility. Is that your understanding of the intent and the Representative Provenza? And then also, again, for either witness, I mean, so the question still is this closing a gap or a hole or not?
Representative Provenza.
Thank you, Madam Vice Chair. Yeah, that is the intent. And given that we have cases that go before post and then are not sought for any criminal statutes, that there's a gap between what we can do and can't do.
Madam Chair, I believe if you look further to 62303, there are a number of definitions prior to A7, which help address those points as well. So, for example, A2 little I, The actor causes submission of a victim by any means that would prevent resistance to submission or ordinary resolution. So I believe that any means encompasses some of those other areas of concern. Specifically to the issue of post, I would note that the example is 10 cases in the last several years, which is 10 too many, of which there were 4 that were sought for post decertification. If I were to wager, I would bet the other 6 were adjudicated in some other manner, not requiring post review. Post is not a prosecutor, post is a licensing authority. So I would be hard pressed to understand that the other 6 somehow maintained their post license. I'm guessing they were disposed of, and the remaining 4 needed that extra push from the post commission to have their license, in fact, dealt with. So again, I would offer that 62303 takes into account several points raised, I believe adequately. Thus, the new statute is may actually be counterintuitive to the existing statute.
Any additional questions? Okay, we are going to go ahead and close. We're out of time. I will lay it back until our next meeting. I know that we do have another witness via Zoom that wanted to testify as well. And so
Madam Chair, if that may have been my witness. So I think we've reached a conclusion if that was John. Thank you. That's my witness as well. So
okay,
I think we're in a good spot unless he raises his hand and specifies otherwise. So-
no, we will reconvene on Friday morning.